I want to thank you all for your patience. We are, like I said, running a little bit late. Today we're going to be talking about, on this session, about copyright licenses, and specifically in the context of government funding and right to access creative works generated by government. And what does that look like? How does that impact organizations, entities, civil society? And I'm going to be, because I'm from Wikimedia South Africa, I was going to be talking about it from a Wikimedia South Africa point of view. And I think that's a good segue into introducing our panel today. So I'll start with myself last. On the far end, we've got Professor Vukosi Marivate, and right next to me, we've got the lovely Dr. Chijioke Okorie. Professor Vukosi Marivate, he's the chair of the data science at the University of Pretoria, and Dr. Chijioke Okorie is with the Center for Intellectual Property Law at University of Pretoria. I apologize, I'm filled with tongue twisters today. Myself, my name is Douglas Scott. I am the advocacy point person with Wikimedia South Africa. We are a non-profit membership organization that represents Wikipedia editors in South Africa. I'm going to give you a brief outline of the structure of the session. I'm going to start off with a brief introduction as to why Wikipedia cares about this issue. I mean, we're a free online encyclopedia. On first glance, it might not seem as though we would have much interest in this question of copyright and right to research. I'm then going to play a short 5-minute video by my counterpart in Wikimedia Germany, Jan David Franke, who will give an explanation on, or a brief account on Wikimedia Germany's efforts to unlock public creative works, or publicly funded creative works, through the German public broadcaster for use on Wikipedia, as an example. And then we're going to start the discussion about why should publicly funded works be freely available, and we'll go on from there. I've got a couple other questions lined up, but we'll see how this goes. So without further ado, why does Wikipedia care about this issue? There's a range of copyright tools and licenses out there, Creative Commons specifically. Wikipedia, and I'm going to be a little bit disingenuous here, when I talk about Wikipedia, I'm talking a bit more about Wikimedia Commons, but Wikimedia Commons isn't that well known. Wikimedia Commons is basically the integrated sister project with Wikipedia where all the images go to live. But for the sake of simplicity, I'm just going to say Wikipedia broadly here. So Wikipedia broadly can only really use 3 Creative Commons copyright licenses or tools. There's CC0, which means that this creative work that has been released under CC0 tool or license is available for everyone for any use, however you like it. Another one would be CC BY, so it's Creative Commons. You got to cite who the author is. And another one is CC BY SA, which means that the SA stands for you got to share it in the same way it was shared with you. These 3 licenses or tools can be used, uploaded freely and used freely on Wikipedia. Any other license, Wikipedia cannot accept. And Wikipedia being one of the largest, I suppose the largest online encyclopedia in the world today, if we don't have access to material to adequately illustrate things, that's a negative impact on the public good, we believe, right? Because we essentially do this as unpaid volunteer editors in the fervent belief that we are doing this as a public good for humanity. There are many other Creative Commons licenses. I won't go into too much detail about them, but suffice to say that different governments use different default licenses. The White House, or the United States generally as a default, uses CC0 with a couple caveats. And that's why I've sort of highlighted up there the White House photographer, their standard license is CC0. The Kremlin in Russia, they use a CC BY license. Now this means that both American government and most Russian government creative works, with a few caveats, are freely accessible for the public and can be used on, say, Wikipedia. The South African presidency, on the other hand, we have chosen, the South African presidency photographer, and this is a reflection of the South African government's choice of a standard copyright license, is more restrictive and is one that Wikipedia can't use. It's CC BY ND. So if you're going to use South Africa, let's say the South African, the photographer of the South African presidency, if you're going to use their photographs, they've got about 55,000 photographs on their Flickr account. They're beautiful photographs. They illustrate South Africa fantastically. We can't use them on Wikipedia because it's not a compatible license with us. And if you are going to use them, you got to cite who the author is, and you got to guarantee that you're not going to create a derivative version of the photograph. And it's the derivative requirement in this case is the reason why Wikipedia can't use it. And the reason why Wikipedia can't accept, say, non-derivative or non-commercial use license types of Creative Commons works is because the community has decided that we can't police that. And yeah, I mean, there's a lot of politics in Wikipedia itself about this, so much so that we've even created a sister project called WMDE, but that is not integrated with Wikipedia. And that is why we advocate for the adoption of the top 3 copyright licenses. But how does this affect Wikipedia? Like what impact does this have on, say, American or Russian government-created works as opposed to South African government-created works? And here's an example for you. So this is the Wikipedia page for President Cyril Ramaphosa. And you'll see his photograph there, lovely photograph. It's quite a high-quality photograph. That photograph comes from the White House official photographer. We cannot use South African government photographs to illustrate South African politicians. And this is a big problem. It means that when we do have photographs of the presidency, they will always have to come from another source, usually the American government, the Russian government, or another country with a compatible default license. Or it'll have to come from another source, that's typically of much lower quality. So there's one Wikipedia editor, a very dedicated South African Wikipedia editor, that's going around capturing stills from very specific video feeds hosted by ENCA, which is released under a Creative Commons license. And so you'll see that most South African politicians don't have photographs. Those that do have either have a very small number of them will have high quality photographs for the reasons I just mentioned, and the others that do have photographs will have low quality photographs because we are just scrambling for source material. So that's sort of one outcome, sort of unintended outcome. And I would argue that this has a negative impact on the South African government's ability to project South Africa's cultural works and share it with the rest of the world. That's a sort of very visual illustration of how it negatively impacts both South Africa and the world broadly. With that in mind, I'm going to play a quick video of what Wikimedia Germany is doing to overcome this, but with the German broadcaster. And the reason why I'm doing this, I know it's a foreign example, it's a non-African example, but the reason why I'm doing this is it gives us a bit of perspective into what has been done in the rest of the world to unlock government works, government creative works for public benefit, and Germany as a case study. And we picked Germany because it's really the only one we're aware of currently. So let's see if we can get this up and running onto the main screen.
In the wake of a worldwide pandemic, access to digitized cultural heritage has proven more important than ever. Institutions such as galleries, libraries, archives, and museums, or GLAM, and other preservers of knowledge have opened up their inventory and vaults, allowing educators and creative minds to find moments of enlightenment and awe. These monumental digitization efforts make knowledge and cultural artifacts, tokens of our past and our modern society, visible. But this isn't just a grand and benevolent gesture. In fact, the public has every right to use and reuse its own cultural heritage, not least because public money is funding public cultural heritage institutions. We at Wikimedia Deutschland argue anything that has been significantly funded with public money must be freely available to the public. Inspired by the Free Software Foundation Europe and their campaign for public money, public code, which started a couple of years ago, we began calling this demand öffentliches Geld, öffentliches Gut, or public money, public good. This applies to all material whose creation has been funded by public money, including, but not limited, to educational content from public service broadcasters, about which I will talk a bit more in a minute, data from government agencies, publicly commissioned studies, digitized collections from publicly funded cultural institutions, public sector software projects. If the public were to be able to freely use this material, we argue, this would have a range of societal benefits. Firstly, it would serve the common good. What is true of physical reality, such as with public parks, must also apply in the digital. Secondly, it would enable users to develop content together and share it with each other. That's how progress is made. Thirdly, it would enhance government transparency. Now that's good for any democracy. And last but not least, it would ensure that the content produced with public money would reach a much wider audience. It is this very argument that may have proved most compelling in our work on public service broadcasting, which I'd like to introduce to you now. Here, our work mainly pertains to educational programs. Our argument remains the same, however. It is all of us who fund this content through our license fees, so we should all be allowed to freely use it. Releasing educational content under a free Creative Commons license, meaning CC BY or CC BY share alike, helps fulfill the mission of the broadcasters to be societal educators. It aids teachers and students by making lessons more engaging and interactive, and it benefits free knowledge projects such as Wikipedia. And of course, it also provides enormous potential for educational content to reach a wider audience, especially through Wikipedia. And so, public service broadcasters in Germany are now blazing the trail on freely licensed educational material. Terra X and Tagesschau, the country's most prestigious documentary and news programs respectively, have been releasing content under a CC BY share-alike license with staggering success. The role of the Wikipedia community must not be understated in this. For years, the volunteers of WikiLove's broadcast have been working with us and other fellow campaigners to intensify cooperation with the broadcasters. They conduct workshops with the broadcasters should they signal their interest in releasing content under a free license to make sure they know how content can make its way into Wikipedia. And they sift through the video clips and check whether they meet Wikipedia's requirements. If they have identified a suitable article for which an explanatory video represents added value, they take care of the technical integration. They have been integral to the success of the two following cases. Terra X has been a long-standing documentary format since the 1980s. After years of lobbying from our end, it began releasing short videos with high production value, explaining specific topics under a free Creative Commons license. The Terra X team upload these videos to Wikimedia Commons, where Wikipedia authors and community members screen them for relevance and integrate them into the pertinent Wikipedia articles. Over 300 videos have been uploaded and integrated into Wikipedia like that. On Wikipedia, they gather over 3 million views a month, having amassed nearly 60 million views in total. The Tagesschau, German for Daily Show, is the most renowned and by far the most watched news format in Germany. A few months ago, they released 55 short animation videos under a free Creative Commons license, with many more to come. In a pilot project, 8 of them were integrated into Wikipedia, and these clips too have been met with a lot of interest as far as view counts are concerned. This goes to show that educational content, when released under a free license, can reach a much larger audience and have a real impact. Perhaps this is of interest to the South African Broadcasting Corporation as well. In any case, the SABC is also funded by public money, and while the TV license fee is about to be dropped in South Africa, the new levy will still apply to all households and businesses in the country. And the SABC even has its own channel entirely dedicated to educational content. Releasing select clips that can be used in classrooms and on Wikipedia would be a win-win for everyone. It would help the SABC reach a larger audience and demonstrate its societal value. It would improve school lessons and aid teachers, and it would be a useful addition to free knowledge projects such as Wikipedia. With those words, I thank you very much for your attention, wish you a fruitful workshop, an enlightening rest of the conference, and of course, a healthy dose of public money, public good.
Excellent. So my thanks to Jan David Franke from Wikimedia Germany for that video introduction into what's going on in Germany. And now on to our lovely panel. I want to start us off by asking, why should government works be free? And what does that even mean? I'm going to open it up to both of you. Whoever wishes to answer first.
Okay, I was thinking that Vukosi would answer because he was on the hot seat yesterday with do or see. But let me speak from a copyright law perspective. So this is more or less, when you talk about like publicly funded works, you're talking about a specific category of work. So it's not like a catch-all situation for all kinds of protected subject matter. And the closest, I would say, the closest analogy to that would be what South Africa has done with inventions, for example, where you have intellectual property rights arising from publicly funded research, speaking to research that has been funded with public money, and where the law says you have to manage and commercialize and deal with those inventions to the benefit of South Africans. And so it just piggies back to the source of, if the public has funded this, why should they keep having to ask for it again when it's something that they funded, it's something that they have put money behind, because obviously it's important to them.
So essentially, why double pay for something that the public has already paid for with our taxes?
Exactly. And again, because you are also looking at the economics of it. If the public has paid for it, they want it to be something that would be useful to even generations to come. And if you have limited access to it, or if you have access that requires you to pay money, it means that our children and our children's children keep asking for something that should rightfully be theirs.
And I suppose there's also a risk of a more perverse outcome even happening, which I'm going to be a little bit controversial here, and I suppose it's not that controversial. It's something that we see a lot in academic publishing, where another publisher will essentially benefit off this publicly funded research, for example, in an academic publication, and republish it and then put it behind a paywall, which the public has to pay to access again. So in that way, essentially it acts as a type of government subsidy for the private sector.
Absolutely.
Many of these many of these companies are foreign based.
Yeah, absolutely. I agree.
Vukosi?
Yeah, so now putting it, okay, our first hat is going to be in the natural language processing space. And just maybe given yesterday's discussion about SABC being a public broadcaster, I think the best it seems to be saying a broadcaster, a commercial broadcaster that has a public mandate as opposed to a public broadcaster, because only 3% of its funding comes directly from the government. So that's that's a reality. And then also at the same time, it does bring up challenges within this space. Does it mean maybe that the content that's created on the SABC education channel comes from the 3%? If that is the case, then yes, you would want people to be able to use Remix, build up more educational content and resources within that space. But I just wanted to make that clarification, because I will speak about language as we continue this panel. But I did want to maybe go back into the data science hat of experiences in thinking about the public good here. So for almost everybody here, it doesn't matter where you are in the world, on the continent, you live somewhere, you pay local taxes. Through the services that you get, in one way or another, data is created. right? This data is created, and there's a point of thinking about innovation in the innovation space of saying, with these public goods, if now that data is made available, I'll give an example of something over the last year I've become very interested in, is just public transportation and movement of people. Again, in an aggregated manner. So we're not thinking about tracking individuals moving around, but if you knew public transportation information about how people move in cities and all those things, this is information that is captured in most cases if you have a public transportation system, especially that has ways to electronically get into a vehicle and get out of a vehicle, that's already there. So one of the things that's an expectation is, oh, that would be great if the movement, the general movement of buses or trains or all those things, given that they're funded really from the fee that a person might use, but then the infrastructure tends to also be built from public money, this will be made available in an open manner, in a way with the license that's permissive to allow people to innovate on top of it on things that not necessarily the local municipality or the government could be able to build right now. And once you start making inquiries of that, you start coming into these spaces of now thinking about there is the principle of, I think, the public good, and then and the data being public information. But there's also the reality of data governance, right? I think yesterday was highlighted on who really wants to sign off on saying that now I've made this available. Right, and so that we can have, I think, connections to open data charters that are available in some parts of the country or the continent, but there's the reality that without proper kind of data governance guidance on how to do this, it also acts as another barrier to making things really accessible in a way. So I'm trying to make the case that it's not necessarily that's the licensing, that's the problem, but there's a practical who actually does it, right, and keeps it up. There's a challenge a lot of times when you go into public service that for somebody to spend money, they want a guarantee that it will lead to something down the line, right? So we can use examples of saying you make some data available, it ends up on a Wikipedia article used as information to back up something, right? But then it's not necessarily that was the case when that data was initially created. So now I can go into the city of Johannesburg, talk to the transportation people and say, why don't you just open this and make it available? And the questions they'll ask is saying, but then we're going to have to put in man hours to make sure that it's updated, kept correctly, all those things. And we don't really know if it's actually going to be a benefit or it's just going to sit there on that part. And that's the other thing. I think that's a challenge, right? Because for them, it's at the end of the day, you need to put in money, an extra set of money that was not planned for, to make that public information on there. Like minus, I think yesterday's conversation about climate data, for example. That's another thing that comes in of like what is supposed, how do we make this actually practically available?
So you've highlighted a really sort of practical limitation to accessing. I suppose the data is not a creative work because it's a reflection of facts, so it's not copyrightable. But certainly the structure of the data you could argue could be copyrighted. But that in itself is not really the big challenge you're facing. It sounds like it's really sort of the bureaucracy and the resistance in the bureaucracy to just providing it, convince me why I need to give you what should already be free.
Yeah, in some ways it's that, and what is this? If you think about that, about that, you then I think add the layers on. Even now, if you have creative works, it is likely the same types of inertia that then block. So the parts on that. Yesterday I said we're releasing a data set next week of in this case you have something that comes, so government communications, their office is not far from here, you can actually walk less than 10 minutes. As I said, they release this Vukosi newspaper. In that case, a journalistic endeavor to create that. And as like, we've had discussions, the South African government license is, it's open, it's like not copyrighted necessarily, but then they don't want you to use it for commercial purposes, kind of on there. So we made a request, a while back to say, we see that you translate some of the articles, let's say 20-30% of the articles, into all the South African 11 official languages, minus may not be available in Braille at the moment. I don't know how that works at the moment, but we might be able to assist with that and then just helping do the conversions. But if we had access to the original Word file, right, not instead of a PDF, it could make it easy for us to make it available again in an easier way, and then people could create derivatives that are useful for many, many other people on there. So there, sure, there's the non-commercial part of, let's say in this case, the license, but the thing that's blocking this is more the part of, we don't really want to release the Word files because there might have been more editing that's done when we were typesetting it and putting it onto a newspaper. And because the version that we have in Word is not the final, this was a long while ago, hopefully my recollection is correct, the version that might be available from the translator might not be the same by 1 or 2 words or 3 words as the one that's actually on the PDF. So we're not making available.
So they're letting,
we can't check, and also we can't, in some feeling, we can't control what will happen in the derivatives part. That maybe that's where the non-derivative parts of it come into those parts. And I'm also saying this on the part of, I don't know what the best way to do this is. I have no answers here. I'm just leaning into the uncertainty and trying to have a conversation so that I can get to something where I can also say, okay, here's how I understand this thing, and how do we move towards trust, and then opening this up to saying, the default without anything should be, we're open, the data's available. It shouldn't be first we're closed because.
So the mindset is sort of wrong, and it also sounds like they're making perfection the enemy of the good.
Yeah, I can see that practically there's perfection part. I don't know.
It's more, I think it's more like a policy versus practice kind of scenario where you, as a default, you decide that we would stay closed until we need to be open, rather than the other way around, where you stay open until you need to be closed. Because even within various constitutional provisions, the rights that are given as fundamental rights or human rights have attached to them limitations. The fact that you have, for example, the right to freedom of expression does not mean that anything and everything you want to say, you just come out and say so. You're not allowed to engage in propaganda or express yourself in a manner as to incite war, for example. So those kind of things are still within the Constitution, serve as limitations to those rights. So it's not as though if government were to have a policy and a practice of opening up or having licenses to these things, it doesn't necessarily mean that they are in and of themselves allowing any kind of uses. But it's more a question of identify what the problem is, because most times we tend to use copyright law and laws as a means of censorship, because there are ambits of copyright law that engages in control, because you have this right of reproduction, you have the right of adaptation, which would include translation, for example, which would include, you're doing other things with copyright protected subject matter. So for me, as a copyright lawyer, for example, I see a photograph, I say this is an artistic work, right? For Vukosi, as a data scientist, he sees a photograph, it's data for him. So because copyright law allows me to, I can say, I won't allow you to do anything with this photograph. Meanwhile, all he wants to do with the photograph has nothing to do with the, what's the word?
The creative input
of the photograph, yeah. Thank you. But more of what can we do, what public good can arise from other uses of this photograph not envisaged. So as a matter of, I suppose there has to be some sort of what's the word, relearning and unlearning, you know, on the part of government. Because like I said at the beginning, this is more a question of realizing that this is a specific category of works. So you're talking about works that are not just copyright protected. They are works that have been funded with public money. And even for the SABC that has this funding model where they say is 3% from the government, that's not necessarily what makes an organization or an institution a public institution. Because some of these institutions, for example, are statutory bodies. They have a fiduciary relationship with the people, as opposed to an organization that is organized and set up as a private institution. So if you're a public company, for example, it doesn't mean that government is giving you money. It means that the public has, you know, shares in your organization. You can't run a public company the same way you run a private company, say a family business where there are, you know, family members as shareholders. Because you have public money in your business, it's not necessarily that government is funding you, you know. So SABC will still probably be, you know, caught up with their responsibilities as a, you know, publicly set up organization. Not necessarily that, you know, they, of course they have to account to their funders, but as an organization they are organized, you know, as a public organization, and they will still have those duties, you know, if government wants to call them out on it or insists that this is a policy that across board, you know, public organizations should have this as a practice, and then they can have, you know, restrictions and the usual disclaimers that don't allow people to do things that are ordinarily unlawful, you know.
So it sounds like there's a tension here between the serving the public good, especially if you're I suppose a quasi-government institution like the SABC, which does rely on its ability to generate its own funding for its own survival. So a tension of serving the public good, but also financing yourself, staying alive, essentially. And it sounds like there's no clear answer as to how to navigate that process.
There will never, I mean, I think life is full of uncertainties, and there's never, you know, 100% surefire way of doing things. But we have to also think about the you know, just like you showed in your slides, you have to think about the impact. You know, what does this do? What problems does this do these policies create for us in our immediate context? Why should the public fund, you know, a particular production of a particular work or a particular piece of work, and they end up having to explain themselves over and over again to use those works? Would it not be a better situation where you have disclaimers where you are not allowed to engage in something that is unlawful? You know, because across the world, you can't, unless you're running a dictatorship government, you can't just wake up and say this is a crime and it becomes a crime. Something is a crime because there's a law that clearly stipulates that this is a crime. This is, you know, the acts or activities that make this a crime, and then this is a punishment for it. So people from the get-go know that they are not allowed to do this, and that if they do so, they would be offenders, and that there will be consequences, right? So I give you an example, for example, from a Nigerian perspective. So there's, for government owned works, of course, just like South Africa, there's provisions within the Copyright Act where government can own copyright in a work. What it then does with that ownership is a different thing altogether. So within the law and in practice, you don't have any sort of Creative Commons licenses attaching to the work. So what happens in practice is that people just use the work until someone says, no, you can't. You know, so what that does is, if nobody says anything, then you keep using the work because, you know, nobody has said anything. But the minute you probably then maybe do something with the work that, is now, something that someone does, or, higher up doesn't like, then they will probably then call copyright ownership into the play. And so it's more of look the other way kind of thing, as opposed to South Africa, where there's even, that policy of a Creative Commons license. It's just that it has these limitations where they then tell you what and what, you can or cannot do, with the work.
So it sounds like this ambiguity and this, I suppose, de facto unintentional criminalization of the public for using public works to, I suppose, create their own derivatives. It opens the way up for using copyright as a tool for censorship. If the wrong person does it and they anger the wrong person.
Yeah, and then it depends on your how large your risk appetite is. If you feel that you can take this on and do that, then you go ahead and do so, and if someone comes, then you can stop. But what if you're involved in, like Kathleen was saying yesterday, you've gone so far, the project is done, it's doing what you wanted it to do, and now you have to stop, So some people can't afford to take that risk of, starting and then having to stop. What if you have funders? What if people are already using this thing, for example, and it's making impact, good impact, it's doing good work, and then you have to stop because, copyright.
And not everyone is clued up on copyright law.
Exactly.
Hence, I suppose it's often remarked as one of the more complicated areas of law. So expecting a regular member of the public to master that is an ambitious ask.
Absolutely. I mean, I think copyright is straightforward. I just feel that, but I mean, that's because I'm biased. But I think also that generally people you only get clued up if something is a problem, or if something is important to what you're doing. Otherwise, you have to prioritize what you occupy yourself with. People are engaged in, let's say, data scientists, for example. They know they just need the data. They know what they want to do with it. They know how much good that can bring about in society. There just has to be a way that policies and laws are structured that allow this special category of works. So if you have a Creative Commons license attached to a work, it doesn't mean that it denies you copyright in the work. Yeah. You still own copyright in the work. And if people were to use the work outside the confines of the license that you've provided, you still can come after them for copyright infringement. But to have publicly funded works that still has all sorts of copyright restrictions, it's a problem in and of itself because of that special character of that work, that it has public funds attached to it. So let me give an example with criminal law, for example. So there's an offense that is called receiving stolen goods. For you to be guilty of that offense, you not only have the goods themselves not only have to be stolen, you have to be aware that those goods were stolen. So if it's just that the goods were stolen, but you were actually not aware that they were stolen, you will not be guilty of that offense. So in this case, they say that, so in that kind of scenario, the courts would say that those goods are tainted. So they are not just, so ordinarily if it's just a bottle of water, it's a bottle of water. But the fact that it's stolen then taints it. So, and that's a negative connotation, right? But when you talk about publicly funded, copyright protected works, they are, I don't want to use tainted, but I lack the English to explain it better. But those publicly funded works are, they are tainted, or they take on
they're
extra,
problematic, and it's difficult to reason.
I'm looking for a positive, a positive word to explain, but they have attached to them the fact that it's public money. So you have to think of them as a special category and decide as a government, in terms of your policy, in terms of your practices, what you're going to do with that work. It cannot be in that kind of scenario that you insist that what applies to other works that are not tainted with that public fund, would still, they would be treated alike. It doesn't work, because even with your freedom of information statutes, where nobody is citing copyright now, everybody is just talking about like dealing with privacy issues, where you have a situation where you anonymize personal information and release those for people to use, and there shouldn't be anything that should be in the way of that kind of specific protected works.
You mentioned earlier on that CC licenses, when you release something under a common license, you actually still do retain many rights, depending on the CC license. And I've actually got an example, a Wikipedia example, that we here in South Africa experienced. About 8 or 9 years ago, the grocery chain, the shopping chain, Woolworths, published a set of pillows, lovely pillows, with a lovely print of a hummingbird on it, and it had text in the background. Turned out the text was all copy-pasted from Wikipedia, and Woolworths had they had a misunderstanding of what taking free content from Wikipedia meant. They didn't read the small print about Wikipedia's standard copyright license. And the standard license in much of Wikipedia's content is CC by SA. And the critical point here, the violation here for Woolworths, essentially was twofold. But the most important one was the by factor, that they had copied a whole lot of text from Wikipedia, reproduced it on a pillow, and they didn't say who the author was. And now that was a violation of Wikipedia's copyrights. And so we had to tell Woolworths this, and Woolworths clearly had a misunderstanding of this copyright license, because they just thought, well, it's on Wikipedia, it's free, you can take it and do whatever you like on it. They thought it was a CC0, and they were wrong. And so they had to backtrack there. I want to explore a bit more this issue of when a creative work becomes data, and how, and how can we navigate this problem? I mean, so you're talking about images, and I know, Vukosi, you've done some work here as well, essentially teaching a machine to look at images, to learn something from the images, but you're not necessarily using the creativity or recreating the creativity in the work itself, but rather the data encapsulated in the image. Can you take us firstly through the technical process of what that looks like, and does that in any way sort of tap into the creativity of the image? And then I want to ask, does this open up the harvesting of images for data purposes? Does that open up this collection of data from images to some sort of copyright exposure? Vukosi.
Okay, this is a very interesting one, because I think minus the topic of the session, because I think there are there's two pieces. There is the part of the informational one. I'll give an example that we're working with the Nkemati University in Kenya. It might just be that you have people who take pictures of wild animals, right? And they do that. I don't know if they're government funded or not at the moment. Let's not worry about that. And then we might want to process as many images of wild animals so that you can just learn. Here's a lion, here's a giraffe, right? So that's a data that's inside on kind of that. And yes, it becomes, there is a very big discussion about, okay, what was the license initially when you put together this data set of those images, that do the people who took the images understand, that it's actually being used for this purpose to, in this case, extract the data, learn something, and then work. That's one case even now. with the major AI conferences, it's starting to become more and more of a consideration that, hey, please include in your ethics statement also where you got data and how you're using it, and is it within on there. The other part that I think for maybe a lot now, because I also get random messages now, people either asking me about the chat apps that are available now or the image generation apps that are out there, is that now that's crossing, I think maybe the line that Chijioke was talking about, where now you could ask one of these systems, the text-to-image generators, I would like this type of painting in the style of this specific artist, and then let's say that artist is still alive. Now it means that you are processing the data to extract the creativity plus whatever randomness on top of that was there. And now there's these discussions that are starting to come along and saying so let's say, like, for example, now not the presidency, but the full South African government they removed the non-derivative requirement, and then they still just have you must attribute that it comes from the South African government. There's probably going to be a conversation by the photographers who, in compositing the taking the pictures, post-processing and all those things, might have thought like, yes, I know this is a commission as per the government, but there's a piece of me and my process in the image, and now somebody else can go onto the Flickr, download everything, and then now create this generator that generates these images. And then again, again, my disclaimer, I don't know what the answer is here, but now it's bringing in this new conversation that on one part, there might have been the processing that was, hey, I'm extracting information for something that somebody might take as a good in the world, and it's okay. But then now when I'm extracting the information to actually be able to reproduce the art, then that's a different conversation. And now even if I had a CC BY share alike, I might not be happy about the extraction of my art within that perspective. And I think in the more computational and data sciences, this is going to be, again, one of those tensions that we have to go through for the next few years, because it's again this David versus Goliath thing. Very large organizations, some of them are just going and just downloading the internet, and they're not really caring about what the original license actually was. And then, if you're very small, you worry that if I was to do the same thing or even use the data set they've composed, I might be more easier to target than targeting them.
So it sounds like this cavalier attitude by the big players would put countries which have a lot of small players, such as African countries, at a disadvantage when building up, say, an AI industry, because the small players, many of which are in Africa, would be too nervous to take
there's a risk. There's, I think, what Chijioke said. You now have to think about that. About what is that risk? In the image generation space right now, there's multiple lawsuits that have started over the last month by artists now trying to sue some of these large organizations, because they're saying, obviously they're not being. It's a worry that people are creating something, I don't know what the right word, that looks like their original work for their purposes without their knowledge. I think that.
Reproducing the artist's work with the AI, and some artists indicated that lost 50% of their revenue or more because of this instead of that.
So because of AI-generated art that is reproducing art in the same style of the original artist, they're losing up to 50% of their normal income otherwise. And that's putting aside, I suppose, the artistic rights of the artist, right? They've developed this style, this unique style over the years, and now the machine is coming along. And I suppose plagiarize is not quite the right word, but certainly recreating that style.
Yes, and there was an issue where an artist passed away early last year, or end last year, early this year, I can't remember. quite a prominent artist from South Korea. He was not dead 2 days. And they imported all his works that was available on the internet into the machine, and they started reproducing everything and selling it. So, you know, it's a big thing in the art community at the moment. I follow it quite religiously.
I've also got an example of the big players sort of being cavalier and sort of can experiment with the limits of copyright law in different countries. It's a somewhat old and mundane example, but I think it's quite illustrative of this. So I'm sure many of us are familiar with Google Street View. So Google Street View, you can drop in on a map and see how a street looks from street level, because Google has gone around taking 360-degree photographs all over the place. Now, in South Africa, we don't have freedom of panorama. So the facades of many of those buildings, that is arguably, it's not proven in court or anything, it's not clear in South African law, but arguably it's subject to copyright. But Google is big enough and so can be bold enough to go ahead and photograph all these buildings and the facades and run the risk of essentially getting sued. I'm very strongly in the position that we need a freedom of panorama so that small players can sort of do something similar and build a domestic industry, but also, from Wikipedia's self-interested point of view, so that we as Wikipedia editors can go around, take photographs of monuments and places of public interest and put them on Wikipedia. Yeah, very, very interesting case. Is there anything similar to this in the rest of Africa?
Not really, but what I wanted to say to that is that some of these things are not the problem of copyright law. And trying to use copyrights, you know, the exclusivity of copyright protection to address those issues would be, in my view, a wrong way of going about it, because that's more a privacy, you know, a right to privacy issue, more like Vukosi was saying, more around data governance in terms of, you know, ethical considerations in the way that you use data, even if those data are copyright protected or not. But to say that because you have copyright in a given work, then you will not allow people to say, so if you're using artificial intelligence to reproduce, you know, what makes an artist the artist that artist is, you know, or the unique creative, intrinsic creative or creativity inherent in a particular artist, their style, how they, you know, approach their creative endeavors. Those kind of things go to the personality of the artist as opposed to as expressed in the work, no doubt, but it's more a privacy law kind of thing, you know, your right to private life, your personality. So when you look at all these data protection laws, you would see provisions relating to data subjects. How do you process data as a data controller or as a data processing organization or entity? This and this are your obligations. People have to know what you're doing, you know, with their data. People have to be aware at the point that they're giving out the data, what you're going to use it for. But that's a data protection problem as opposed to a copyright problem. So using, but of course, using copyright, for example, is going to create more problems, and I think that it's something that tries to use a particular piece of legislation for what it's not. So in Kenya, I think last year, there's this company who publishes judgments, court decisions from Kenyan courts. So under a specific statute, you're supposed to, courts are supposed to deliver a copy of their decisions to this organization. I think it runs with the Attorney General's office or Ministry of Justice or something like that. And so they publish it for free. So you can access decisions of Kenyan courts on this particular website. So there comes a company who was involved in a lawsuit, and in that lawsuit, the court delivered judgment in that lawsuit, and this web platform publishes the judgment. And these people says, oh, the fact, and they don't add anything to the judgment, they just publish it the way that they received it from the courts, right? So these people then say, you have to take down this particular decision because it violates our rights to privacy. In fact, you don't actually publish all decisions that you receive. So why did you choose ours to publish? And the courts, in arriving at a decision, of course, the courts dismissed the application, but part of the decision and part of the reasoning in that case was about copyright. The court said, remember that decisions of courts, legislative tests, are outside of copyright protection. And so you cannot even on that basis restrict someone from making a decision as to which judgment of court to publish or not, right? And I mean, legislative, even with the Copyright Amendment Bill, we can see how much effort goes into drafting these pieces of legislation. Is there creativity involved in them? Absolutely. Is there originality? The very things that we look out for in saying that this work is copyright protected. But because it's something that is for the public good, it's a statute. It's a decision of a court. If you write, as a lawyer, if you write a legal opinion for your client, you would be putting in as much work as, or maybe less, but as much work as a court would put in weighing the two, briefs of argument and in arriving at a decision. So assuming you file a brief of argument in court, you've put in the originality, you've put in creativity, different lawyers write differently, present their arguments to court differently. They leverage on published works, previous decisions of courts propagating their cases before the court. But these things are outside copyright protection for a reason, right? Because it's a public good. It's for the public, by the public. It's something that we're doing for ourselves. So we have to be able to separate what is a copyright problem from what it's not, so that we don't use so that doesn't cloud our decision when we decide what kind of license is appropriate for publicly funded works.
Yeah, and I suppose in the area of data, it's easy to slide in between different areas of law and away from IP law and copyright law. It does, this whole conversation, and especially Vukosi, what you were talking about in accessing data, and the barriers, I suppose the default, the attitude, that's the word I'm looking for, the attitude of government. How problematic would you say is this attitude? How would you describe this attitude? And for the sake of this, I know these are big questions. For the sake of this conversation, would a clearer or simpler or different default copyright license by government as a pillar of policy help resolve this? Not necessarily in accessing the data, but perhaps many of their concerns about sort of the creativity and maybe how the data is structured or accessing images, those sort of things.
Yeah, so I think to begin with, and as a disclaimer, look, I work with public institutions a lot, and even if I get hit 1,000 times on the head, I will stand up again and go for the 1,001 time because of the public good. It's a very important thing. Sometimes it's like people will just think, oh, it's a lost cause, don't deal with that. But it's a very important point to have, one, create trust, and then from there have these conversations, right? So maybe sometimes if you've heard me speak, yes, I'm very passionate about it. I might feel bad at that moment, but I literally wake up tomorrow morning and go like, okay, let's do this again, and on that part. So I think myself and Kathleen are sitting on for example, the AU task force that's working on the AI policy for the continent. And one of them is thinking about this data handling and policies and things like that, and copyright will be in there. But one of the things that we keep on identifying over and over again is like, it's likely more going towards the governance as opposed to the licensing on there. Yes, we would love to have a single data market. You would want to know that if you're interacting with public goods or public data across the African continent, it's treated the same way. You understand where you stand very easily, and then we've got a default license, minus the limitations that might be put off saying, yes, this is available to you, but you can't use it in this way and this way because of either privacy, security types of things and on there. And that's what some people are trying to go for. The EU is trying to make sure that it's in that way, that we understand that also in the same way. And there's the limitations, because as soon as you cross over to Germany, that even if there's an EU law, there's sometimes also special restrictions because you're in Germany, for example. When it comes to these things. So my one maybe again is not I've enjoyed being here because learning, especially from the lawyers, again, it might not be a creative work, but we had the situation of thinking about COVID data and extracting from these works. I don't know if the people who are writing them, the minister statements and all those things, people who are creating all these infographics. And we initially had just said, can we just get access to the original Excel file that you're keeping track of anyway? You have to have this thing. And the answers were like, what are you going to do with it again? And then no, there's a practical point of view of releasing it. Even today, I'm telling you this. You can go and say, I would like to get access to South Africa's daily COVID numbers for the last 3 years. There's no way you're going to get it that comes from a South African government source. Even today. Like there's, in terms of just having a simple file you can download and then say, I just want to plot it myself, so that I can see and make any adjustments on there that you can think about as a public good, right? That you could be somebody working in epidemiology, you want to use that. You could be somebody working in public education, you want to do that. You can't. It's not there. Our lab has it. And we had to do it via creating a huge volunteering project that went, every time an infographic was created, somebody had to go read the infographic and then enter the numbers by hand. Right, the PDFs that were the statements, they had to go there and extract that line from the PDF and then recreate it. And then we re-released it under a Creative Commons share with attribution. And if you go to the Wikipedia article about COVID in South Africa, the graphs that are created there are created using our data. Right, and I was just checking now, and I wasn't sure.
It is.
Yeah,
it
I
is.
was actually checking now. I just wanted to check, and that's what's happening on that part. And now there's this question that comes up naturally, but we have this as a public good. We, in one way or another, funded it, but from a bureaucratic point of view, and maybe this is closer because I can say this to a room. We've all collectively gone through this pandemic, and we can understand that. But just think about all the other corners of our world where somebody might be in and asking, but this should just be something that's available to us because of it's a public good. And maybe I'm illustrating this point of saying why it's important for the publicly funded information to really be accessible to the public, and not this part of blocking it out and saying no, it shouldn't be, because in health side, it could save lives. In other parts, it could be representing our country better. I don't know about obviously the non-commercial part. I think, Chijioke, I would ask you to talk about the thoughts of a government saying that we have a non-commercial, it's a public good, it's released, let's say in images or something like that, but people can't use it for commercial purposes,
or non-derivative,
or non-derivative, or whichever one. I would like to learn, or maybe other people in the in the audience who have thoughts about this, I think it would be great to have that conversation within there. But there's these parts of really thinking about this, of what happens in the same way that you might have commissions. One that I've been interacting with a lot is children's books in our local languages. You might have commissions that come from our education department on that part. And you see that they do release some of these things on these parts of saying, no, this is copyright free because we want people to print it out and be able to teach their kids, and then it's available to everyone. But then it then shows that there's this, is it the same understanding that we have here? That you can go to one part of the public service and they seem to like embody this thing of saying we need to do this because it increases access, it increases people being able to learn wherever they are, they can learn in their language. And then you just literally, if you're in Pretoria, you turn a corner and it's a different building, and in that building they just say, no, that's not something that we kind of do. And they won't reference copyright necessarily.
Yeah.
There's these practical things that they'll just go in and say like, well, it's a policy we know, and there's more policy that's coming from the South African government that has to do with data, in the view of data, and that likely will influence copyright. But I keep on thinking about practically, for the person who needs to assist you in getting access, should it always have to be a prior request? Why is it supposed to be under litigation almost, as opposed to being, it's open? We're trying to make sure that people have access to these things. But as I said, I'll be very interested from the lawyers in the room, from Chijioke, about this non-commercial or non-derivative part, and how what is the public service supposed to do in that space. That's my feeling, yeah.
Any ideas on the non-derivative, like why would government go for a non-derivative license as a default? From the audience, I'm very open to taking comments on this issue, or even questions for us as the rest of the panel, because I can surmise some issues, but I don't know of any official policy on this.
So you have, let's start with the non-commercial restriction, right? So as a body, Wikimedia doesn't mind the share alike license, right? So
we really like the share alike license, that we love. We don't like the non-derivative license, and we don't like the non-commercial license. It's a divisive issue within the Wikipedia community. There are people who think that it's good that we don't accept non-derivative, and it's good that we don't accept non-derivative and non-commercial images, because we just can't police their use on the internet. The internet's too big. And then there are others.
Sorry, by can't police, what does that entail?
So let's say you submit an image to Wikipedia, to upload an image to Creative Commons. And you donate this image, but you donate it under a CC by let's say ND license, non-derivative license. So you're uploading it, you say, yeah, I'm sharing it with the rest of the internet. All you got to do is just say that I'm the author, and no one else can make a derivative work of my photograph. Now, Wikipedia, Wikipedia won't like that. We won't accept the image, because we will say that we can feature. We will try to show that to ensure that other people, when they use your image, will cite you as the author. But we can't guarantee that people won't make derivative works on it on the internet, because it's the internet. Like, people will memify it, for example. And this is supposed to I show a bit of my personal feelings on this. I question that, because I don't see how the community can even ensure that that people will cite you as the author. So my personal feeling on this, and you can see which side of the debate within the community I sit on this, is that we should allow ND, non-derivative, and NC licenses, because really our ability to ensure that people don't use an image for commercial purposes or create non-derivatives of it is about as good as our ability to ensure that people always use the author or always share your work in the same way you shared it with us.
Yeah.
Which is to say, it's very haphazard, quite random, and minimal. So we might as well just accept it. I want to start on the Q&A session now, because I see we've got a question from Zoom, and I want to know if we can start the Zoom question. Simi, I believe you've got the question for me. Or should I give 5 minutes for the question to be given to me? But in the meantime, oh, thank you so much. Here's the question. So the questioner asks, I'm curious about derivative works and the scientific data or statements. If stated, the temperature has risen by 1 degree, can someone publish a derivative work that says the temperature has fallen by 1 degree, or can the data be changed? What recourse do I have if my work is misused? I suppose the creativity there would be just in the writing style, like what is written, not the data itself, because the change in temperature is a reflection of fact. You can't copyright that. What you can copyright is the artistic prose in which you've written it. That would be my answer.
It's more, what is a derivative work?
Yeah.
It's work that in and of itself it's original as well. It would qualify for copyright protection because it would have the eligibility criteria for copyright protection, originality fixed in a material form from which it can be perceived, right? So a derivative work makes you remember the original work, but it's not a reproduction, it's not a complete copy of the work. So if you had, if you had a novel, a work of fiction, and you make a movie out of the novel, the movie is a derivative work in that it will remind you of, it would even stay true to the storyline and the characters and all that, but it's now expressed in a different medium. So the movie is derived from the book. So if it's just a statement of how, by what degree the temperature has risen, and someone then, changes it to that the temperature has fallen by, it's not a derivative work. There are specific features that makes a work a derivative work as opposed to a reproduction, like a copy of a work. And there are, cases across Africa, across many parts of the world, when you're looking at whether a work is a reproduction or an adaptation. In here in South Africa, in the blind essay case decided by the Constitutional Court, there was that argument before the court around the question of whether if you're making transforming or changing a written, like text to, text to speech, what you're doing if you're converting text to speech. The court was asking the question of, is it a reproduction or an adaptation? Bearing in mind that maybe you're translating, for example, a work of fiction or a written textual work into Braille or into a language that someone with any kind of maybe visual impairment or visual disability can be able to perceive the work similarly or in the same manner as someone without such disabilities would be able to. The court did not arrive at a definite decision around, what makes a work, that kind of scenario, what makes a work a reproduction, which is basically that you're copying and pasting. And, because if you're making a translation of a work into another language, it's a derivative work, it's a work of adaptation, because you'll be giving it context, you will be applying, you're not just, if you translate from my language, for example, if I translate straight literally from my language to English, it won't make sense, right? Because I have to translate it in a way, because I know the two languages, I have to translate it in a way, you know, fixed in. So it won't be, I have a red apple. It won't be, I have apple red, you know, maybe because that's how my language is structured, you know. So there are all those things that you do in the course of translation that makes it a work of derivation, as opposed to just maybe changing facts, you know, around. I hope that answers the question.
Thank you.
Okay, so it's not really a question, it's more of a comment to Chijioke about what you were saying in the beginning and a little bit what you're saying now, just now. Because I'm Giovanna, I work for the Wikimedia Foundation and the Culture and Heritage team. So like the things that you were saying, they are like my day-to-day job, basically. To convince institutions, especially museums, libraries and archives, on why they should open their collections and upload them to the Wikimedia projects. And in the beginning you said, and I know that you kind of already answered that with your example of the COVID data, but you mentioned how it's difficult to convince those organizations. I think you used an example of transport at the beginning, if I'm not mistaken, and how difficult it is to convince them that once you do this work, the data will, you will do something with that data and it will not just sit there, right? And I think you illustrated that very well with the COVID data example on Wikipedia, because as a crowdsourced platform, we know that that data will stay alive and that people will do things with it, right? And more than that, it is a volunteer work, so it will continue there and continue to generate this public good that is related to the data itself, but also the work of those volunteers. But also I wanted to bring, that's why it's not a question, it's more of a comment, because I wanted to bring some more examples of how that data stays alive. So we have a query system in our, that are connected to our platforms, especially the Wikidata platform. And once you put that information there, that data there, you can query and search it in a different way, and you can create like several kinds of illustrations that you can do with that data. And more often than not, once those institutions, heritage institutions in my case that I am more close with, they often find examples of gaps in the knowledge connected to that collections that they are making available, and they discover new ways to research with that data, new pathways of researching with that data. And also it is available to be translated in like more than 300 languages that we have on our projects. And it also can be connected to other databases that are also available there. So, so when I am approached by institutions and they want to do projects with us, but they are worried that they will do this huge work and that the data will just sit there, these are the examples that we use usually to say, like, this is a crowdsourced community, your data will stay alive, it will generate translations, more research. And usually we also, like in my team at least, in the way that I have been working for a few years, we have like a plan or different phases that we work with those institutions. And the last one that I usually say is the dissemination phase, in which after you do all the technical work and you upload them and you notice and you make sure that the licenses are correct and all of that. And once everything is done, you can then start from there to actually do what it is interesting, which is disseminating this data and this knowledge beyond Wikipedia. Using, of course, on Wikipedia, but then using in several other ways. And we are also always approached by the not controlling argument, like not, once you upload them to Wikipedia, you don't know what is going to happen. And this is especially the case with multimedia, with media. This is a preoccupation that usually museums have, as they are a different kind of institutions than library. They have a more, libraries have more of this kind of let's borrow our content. They kind of already have that kind of mindset, and museums are a little bit more closed. And they are worried about this, like we are losing control of our data, of our files. How do we deal with that? And what we say is that, like, if it is available on the internet in a not very good quality way, people will use it. Google will use it. You know, that's not, you are not controlling it anyway. You might as well choose the right way to share it. So we have like this very famous case of the yellow milkmaid. I don't know if you are aware of that example, Douglas. I can talk to you a little bit about it later. But it's a very interesting one because this museum that was very concerned about one of their paintings having like several different versions of in the internet, and people would see the image in person in the museum and not recognize because it was just so different. And they chose to upload to the Wikimedia projects that image and several others because they realized that once they did that, the main image online and that people would see would be the one that they had uploaded, that the one that they had made available. So they would make sure that people would know that that image came from the museum and that they were seeing the correct image with the correct color. And there's like a whole article about that that I recommend very much. And yeah, that was it. Sorry for talking for too long, but it's just like a direct comment to what you were saying, because I was just thinking how much we have in similarities in our work. So, yeah. Sorry.
Thank you. I want to quickly dive to, is it Igel from on Zoom? You got a clarification or expansion on the previous question that was asked. Please go ahead.
That's correct. Am I audible to you? Can you hear me?
Yes, we can hear you loud and clear.
Excellent. I speak as a scientist involved in open science policy with regard to data that may be quoted, for example, in Wikipedia. CC licenses are extremely important in open science, of course. But suppose I publish some data, there is a decision or advice or note from our National Intellectual Policy Management Office that data can be copyrighted. And suppose my data is misused. Suppose that a data point is changed in a derivative work. What recourse do I have in that case?
Oh, it's a lovely question. I do have an instinctual answer myself, but I would love to know what you folks have to say about that.
I can try quickly say like the wrong thing. I have no idea in this case. I guess with the COVID thing, I think we'll probably just roll into it, Douglas, in the last 30 minutes. We know, like, in terms of the structure, the way that we've created the structure, it's our way of interpreting the data and on that part, but we have no idea where our data has ended up and if people are actually abiding by the license in any way. It's always fascinating sometimes that's where you find it, and I mean in terms of how people are kind of using it, and then there's no attribution, and they're also not trying to kind of now continue sharing it in the same way. This being South Africa, again, please listen to my disclaimer from before. There's likely a lot of people who've made a lot of money out of it. Right, and repackaged it and then sold it on as different ways or added services that they run on top of that. But I don't, it's hard. I'll probably have to go to our lawyer's office, which is next building. It's not far, and then saying, hey, let's go after all these people. But as I said, like for the public good side of it, we, like, you know, if it does help people, I don't think we're going to go up against it. Not saying it might not be for legal purposes. Yeah, if something obviously is egregious, then there might be some way. But the question was good, but I don't. Yeah, I personally don't at the moment have an insight. Maybe Chijioke.
Whenever you hear recourse, you just say, lawyers, you should know what recourse one should have. But I mean, if it's a case of a clear case of copyright infringement, then obviously you decide whether you want to take it to court or whether you want to write a cease and desist letter. If it was a case of using the work for the purposes outside a license that you've given, obviously you have a case for copyright infringement because you own copyright in the work. You've obviously said this and this and this are uses that I allow you to make of the work. So anything outside that, and which is covered by my right as a copyright owner, then, you know, I would have a right to take you to court. Whether you then decide to do so or not is an entirely different thing altogether. Apart from that, if it was a situation where maybe the misuse of such scientific data or information is risking lives or affecting lives, obviously you would have recourse in one law or the other that has to do with, you know, public harm or harming people with the scientific data that you produce, right? But in terms of in practical terms, you could also, without, you know, going all legalese on the matter, it can be something as simple as maybe publishing a rejoinder or a clarification or something that, you know, puts it out there that this is not the actual fact. Using Inge's example, if it was that the person was misrepresenting the facts as you have put it, backed up by research that you've done or something like that, you could clarify or elaborate in subsequent publication or in disclaimers and things like that.
Yeah, that would sort of my instinct as well, is to separate out this this issue into what is covered by copyright and what is not. And the data itself can't be, because a reflection of fact. But the way the data is structured or organized, you could argue is. I don't know the legalese around the copyright of structuring data. I just don't know that. But that would be my instinct, is to go there. And then whether the data is misrepresented, that sounds like it's sort of out of the certainly my purview. Yeah, that's certainly out of the purview of copyright. But I do want to use that as a neat little segue into what is our second segment. And I know, Vukosi, you already. Okay, yes, because we've only got 10 minutes because we started like 15 minutes late. Yes, sorry.
Okay. My name is Setlalemetse Sekano. I'm from the GPAA, which is the biggest government pension fund. So we're administrating. I'm a knowledge officer. So what the government has realized was the fact that we have a problem of sharing information even within a department. So let alone to share with other sister organizations. To make the work more efficient, in our case, to ensure that we pay benefits on time, because sometimes maybe we don't know something about a beneficiary and we just want to contact them. We can go to SARS and ask for their phone number, but sometimes it becomes difficult. So we have to actually go and fight, and at least now we've won. So they can give us some of the information. So I understand that it would be extremely difficult to share with other organizations, for example, like the university now, the Wikipedia, which is troublesome. If I can't share information with somebody in my own house, it's a problem. And I think it comes from a culture issue that we're trying to actually resolve. You can imagine during COVID, people not wanting to share information and people could not even come to the office. So what the DPSA did, the DPSA is the employer for the government. all employees are employed by DPSA. They have decided on having the knowledge officers in each and every department, and we have a forum where we discuss how we can actually share information, even amongst ourselves as knowledge officers, to make, have a portal where you can actually get information. So I found this conference very interesting because I will go back and discuss the issues. Because also, as a matter of fact, I come from a risk management side, and I was very worried when I heard that you take information from somewhere and then you copy it, or you try to capture it. So from where I'm coming from is, what if this information, you make a mistake? People can make a mistake. I mean, we had somebody who had a nefsas bursary. They say it's a mistake. So inherently, if you're a person, you'll make a mistake. So I think it would be better for us to capture our information on Wikipedia, because we ensure that it's actually correct. And that is the latest information that we have. And I know, as a matter of fact, that we also have another issue to say, sometimes we don't know where the final document is, but it's something that we need to change and ensure that we publish the final document. In my department, every document that has been that served at all the committees, I will then take it and publish it. So this is the last document that we have. And I think that is something good that government is doing to ensure that you know what is the latest document, and we can actually publish our own information. And the fact that somebody will actually use it for something else is neither here nor there. You don't, it's like raising a child. When they grow up, they can misrepresent you, but at least you've made an effort to do your best. So we can give the information out there. People can use it the way they want to. I don't think that is our business. So we need to just make peace with a lot of things. And I think that I'm very happy with what the government is doing. And yeah, we'll put it out there. And I think we would come up with some sort of an agreement on how we can do these things, because then everybody sits. So I'm saying on a national level, we set provincial level, and once in a while we would have a forum where everybody comes, and those are the issues that we would try to resolve for the public good.
Yes, please. Yes, please do.
Yeah, I think I'll connect this to the COVID thing. And I think on one side, it's understood on the side of our POPIA or privacy laws. The whole point of moving personal information is not necessarily the big thing that we're discussing here. We're not saying personal information should just be, even if we're just willy-nilly out there, it should be on some parts. And also because I worked at the CSR and then working on the side of research in the public sphere, yeah, there's many conversations about should we have a single government, a national identity that allows you to interact with government systems in such a way that people can either with granularity give permission to say this department and this department can share information. I've approved it. Right now, what that has to do, it always has to end up at the ministers, and then the ministers that's why getting information from SASA becomes a thing. That's just past life. So I know how hard that is, just to say you're going to ask, even with all the protections and saying that this is for a good and it's going to be safe, secure, and with the respect of the individuals that the data actually represents on that part. But on the side, I think that one thing I picked up that's very interesting and for people to think about was this question of, given the provenance of the data, where it came from, if there's a mistake, what happens on that part? And in COVID, that happened, right? There were times that the minister would come in and say, oh yeah, we made a mistake in counting, and then there would be a backfill from a practical point of view, meaning we go backwards and then we adjust the numbers. For us in the data field, that's okay. All you do is when you upload the next version, there's a note that goes with it that says, on this day the minister let us know that there was a issue with the data, and here's the latest version with all the fixes. And the reason I say that is with the example I gave for Vukosi, for example, that is the challenge of there might be an adjustment before the newspaper goes outside. And then we had a version that was translated that doesn't have the change. And for us, it's like, but as long as it's actually written that this is the pre-final version, and that's what's being made available to people, why is that not okay? Are we like, really in that part of everything has to be perfect? Everything. And if we are within that space, especially for something like this, where it's about civic education, understanding how the government works and all those things, I always worry that these things will not end up necessarily in the National Archives properly. And then again, 50 years from now, they never existed. And we had this opportunity of just saying, we can just, they're in a license that's very permissive. Let's make them available. And there's other people like myself who are like, we want the very soft copy of this. And they're like, here's the very soft copy in terms of it's a TXT file. No formatting, nothing. It's just on there. And those people will then build on there. If on Blind Essay creates an automatic thing that now reads that TXT file, does text-to-speech, that makes sure that people can have a Braille version, that's increasing where these content actually gets to and improves civic education. So I'm not too worried about provenance, and this is the same. It wasn't just about COVID in terms of the numbers. In the same way where we talked about vaccine things, it was the same questions that kept on coming up. What if we made a mistake and now we counted wrong? And you're like, why are we worried about that? Fix it, update it tomorrow, it comes back up and says there was a fix. Are we going to wait 10 years and only 10 years from now we're going to be definitely going to be able to say this is the final file of COVID 2020 to 2022 and that's the only time we're going to release it? But the use of that information might have already expired almost, and then there will be another complaint that, we released it after all this work, we spent all this money, and now nobody's using it. So I think there has to be that part of understanding that if there's a mistake, it's a mistake. We fix it, we adjust, and then we re-upload with it, because people can always go back to the source. That's the point. If it's on your website, we will always say it comes from here. People will always go back there and say, I can get it, and I need to check what Vukosi's version is actually the same as what actually is on there. And if there was changes, I'm now going to use from where it actually came from.
I'm Denise Nicholson from Scholarly Horizons. I just wanted to say that data generally is not copyrighted. So if someone takes your data and makes a mistake, it's incorrect, but it's not copyrighted. But if it's a copyright work and they're distorting it or making it incorrect, then you have a moral right that you can protect, because your moral right protects your work from distortion or plagiarism. So you could make a point if someone's plagiarized your work or they've distorted in some way. But as an academic, I would try and rectify it. If you feel it's really wrong, is to write to whoever's done it, point out the damage of creating false information and see if they'll change it. But maybe they're doing it on purpose, so it's difficult to change if it's it's not copyrighted. But if it is to do with your moral rights, you could possibly do something. And then the second point I wanted to make is about the non-commercial Creative Commons license. Many years ago, I sat in a meeting in London with a whole lot of people. Tobias was there as well, and they were talking about the non-commercial, and the guy from Creative Commons himself was confused as much as we were. And we always said rather stay away from it, because you could want it to be non-commercial now, for example, in a thesis or dissertation, but once it goes to be published, it's now commercial, then you can't use that work. So to stay away from it, so people tend to say rather not use it non-commercial, because it stops you at a later stage. You might use it for non-commercial now, but need it later for commercial purposes. So best to not use it as one of the choices.
Probably the origin of the wiki community's suspicion of the non-commercial license, and why we don't really want it on Commons. But yeah, in Wikipedia it's a bit more complicated, because you can upload stuff to Commons under the standard sort of CC BY SA license or CC0 license, or you can make a upload to Wikipedia itself and try and make a special case, and you argue something that's often called the fair use argument. Obviously it doesn't really translate well here where we got fair dealing, but and that's where you try and make a special case, and you could conceivably make the case there for a non-commercial work. But yeah, this is a complicated area in Wikipedia.
Thank you.
Yeah, I think maybe this is also another from typically with research organizations, especially public ones or academics and universities, sometimes the non-commercial I've picked up is a challenge. The non-commercial clause is a challenge because of funding, right? If you look at the R&D spend in South Africa, most of it comes from the South African government and it's taken as public. But there's, in terms of the wider scale on the African continent, how much money comes from private organizations that give money to people to do research. And it might just be taken, in that case, in terms of the interpretation, that if this private organization is giving you money to do research, now you can't touch non-commercial works as part of your research, and that's another part. So some people are typically advocate for not using the non-commercial for that. I'm providing this as information again. I'm not providing an opinion. I'm still learning, but I've seen that as well. That people try to, because of the huge amounts of funding that come into research that come from private organizations, and they're concerned that they can then touch research material because there's a non-commercial clause that's sitting on there, or there are people who they fund can do research in what we would view as a normal kind of way inside a university.
Before we go on to the next and I suppose final question, just on the issue of the non-commercial argument. Surely for economic development, I mean, this is an argument against using the non-commercial use for government. Surely you want to cultivate domestic industry by allowing at least some data, some creative works to be used for commercial purposes, to, I suppose, foster infant industries?
Yeah, like for me, I think maybe sitting in the innovation space, yes, there's always this interesting part of somebody could find a way to do something that opens up a whole new part of an industry that we didn't know about with the works that are there. And that's the part of, in the case of really thinking about practically, people need to make a living. And there's the other part of saying there is a living that has to be made by the person who creates at the beginning, and how the compensation happens. But then there's another part of, if you invest in saying, here's a process that I'm now going to create on there. And then this might then sound like, yeah, but then there's these text to image things, and they've spent a lot of money training these models, so they should find ways to monetize. But then there's a spectrum of how do we figure out where everybody gets compensated in the right way, they get acknowledged in the right way, and they also have they understand what their rights are when they make those works. Because sometimes that's a part. Sometimes I see, maybe from the academic side, I note is that there's not enough time also spent explaining and to the creatives or the people who create the content, what are their rights, what are their license options, so that they make an informed choice. I take it for me as a criticism of academia. People go in and say, oh yeah, let's do this. I take it, and then the person then finds out later that if they were looking at the compensation part of it, it actually didn't match their loss in what they would have thought is revenue from the copyright that there would be going on. While if it takes you an extra 15 minutes to really educate the person who's the creative, they can willingly say, oh yeah, now I understand it and I understand this, and it saves the hurt later on. And at the same time, they might say, look, I understand what you're trying to do, but I would like to reserve some of my rights as well within there, and you come up with a better agreement. And that, I think, builds better trust in going forward than the short term, I'm just going to do a hand-wavy thing, and then the person just signs at the end of it, and they don't know what actually is going to happen later on. Yeah. Thank you.
Yeah, I suppose you could sort of create some very poison the well and hurt a lot of people if you don't take the appropriate steps. For our final question, I want to go to Zoom. We've got Gabriel on Zoom. Gabriel, please ask your question.
Good morning, everyone, and thank you so much for this opportunity. I want to also thank the facilitators of this very, very informative session for doing that and giving us access to that. I appreciate that the discussion is around more the implications of copyright rather than the Copyright Amendment Bill itself. So I don't want to divert the conversation too much to that in this very last question. But I would be very interested in getting some comments from the panel. I'm referring to a paper that was released by WIPO under the heading, I think it was released in November 2020 under the heading Intellectual Property and the Creative Economy. So the premise really is here the creative economy, and if one goes from the perspective that globally, like with any other sector, there's an available consumer base for creative product. Be it music or the arts or fine arts or whatever it may be in the creative sector. And South Africa is also one of the players in that sphere. And it stands to reason that those with greater access of control of the media, the conventional media, television, radio and print media, and modern times, the social media, would obviously have a better chance of a bigger portion of that consumer base. Now, when new players come on board, and particularly developing countries such as South Africa, our cultural product has been proven to elicit an appetite globally. I have to mention, things like the Lion King coming from the African continent, and South African product, the likes of Miriam Makeba and Yuma Sekela and so many others. Modern day, a guy like Black Coffee, the massive impact that he's had in the more modern contemporary music scene. So here's the essence of my question. As TUMSA, the Trade Union for Musicians of South Africa, we've been campaigning for the Copyright Amendment Bill to also reflect the need for, to some extent at least, ring fencing, a consumer base or a consumer reserve for access to local producers of creative product to be able to have access to available media, both in the country and internationally as well. And we believe that there was room for such a clause within the Copyright Amendment Bill to specifically point at local content and, perhaps an initial period of quotas, etc., to be able to kickstart and provide seeding for such a creative product to take a foothold within the hearts and minds of South African consumers, but also to be able to make inroads into the international market and have a fair, access and a fair foothold for our creative product to take root, all over the world. So I would like a comment from the panel to the effect of, do they believe? We've been met with resistance. Every time we mention local content, then the resistance have said, no, the Copyright Amendment Bill is not the bill for that. That should be in the Broadcast Act or Intellectual Property Act, etc. We believe, such as the example set by WIPO, that the Copyright Amendment Bill was the perfectly best bill for it to be contained in. I'd like some comment from the panels, and thanks very much for indulging me.
The Copyright Amendment Bill is such, it's a hotly debated topic and issue. When it comes to local content, I mean, if I'm to give examples from other jurisdictions like Nigeria or Kenya or Uganda, for example, that I'm familiar with, issues of promoting local content is, readily dealt with in the broadcasting code. And the reason for that, I've found, is because the broadcasting code is styled or structured in such a way that, by the legislature, in such a way that it's a regulatory code, so it changes, from year to year. So you observe the broadcast media, you observe the industry, and then you make adjustments to the local content quota as as the context demands or as the situation demands. So putting local content promotion in a copyright statute, I don't think that it would do much. I think the place for it, but that's my personal opinion, and I'm not speaking for Parliament or for anyone for that matter. But from my own perspective, I think that because broadcasting codes change, is able to change every year as the broadcasting authority observes, the situation of things, it's more situated, it's better situated. But that's my personal opinion.
Yeah, it's also a bit outside of my area of expertise and knowledge. That was supposed to be the last question, but I suppose we can take one more, and then we got the tea break. Yeah.
Just talk.
Okay,
yeah, just talk it.
Thank you. Speaking of the local content, I think it's quite an important topic. And recently, especially in the music industry, I just wrote a paper showing the impact that technology has in, maintaining or destroying cultures. As an example, in the music industry, that many people in South Africa still live in the rural communities. I mean, they are rural communities, and they don't have access to the internet for streaming, because right now we are no longer, playing tapes on the tape recorders, and even CDs are phased out. So the platform or the medium for music consumption is one that is not accessible to the local communities. And when you go to this new platforms where music is consumed, you find little South African content. And if you're going to find little South African content there, that would mean new generations will not get to know what the South African Kwaito, for instance, or Mpangani, for instance, they will die. And with the death of that music is the death of certain cultures within South Africa. So I think it is important, but I'm not sure if it can be dealt with through the copyright discipline. But it is one that has to be dealt with. And obviously the laws have to be read together. If it's in the Broadcasting Act or something like that, they will apply. I mean, in Canada, for instance, as far back as 1997, the US had to ask for consultations at the international level, at the WTO, requesting consultations with Canada, because Canada was, like any country, perturbed of Americanization of culture. So Canada had to, place a ban on importation of certain American periodicals, in order to promote Canadian periodicals, because the feeling was that the Canadians prefer the American content over Canadian, and that would mean the death of Canadian culture. So I think it's something that we need to do, but like I said, if you go back to the history of intellectual property, I don't think that the aim of IP in general is one that has to do with preservation of cultures by using certain avenues, such as quotas or local content. That's my 5 cents. Thank you.
I know that this is also a source of great anxiety historically in France as well. In terms of preserving culture, and Wikipedia, we always encourage people to upload their own creative works to help illustrate, say, cultural output like music. But Chijioke, I don't know if you got an answer to that or a comment.
To upload.
Oh no, to the comment.
I think we are aligned. I don't think that I know and I support that local content should be promoted. the very the fact that copyright protection exists is in a way promoting culture, even if it's not preserving it necessarily, but at least it's promoting culture, because people, it helps promote creativity, because there's, you know, all these incentives from the exclusivity that you get out of copyright protection. But do you want to promote local content within a copyright statute? Copyright is not quite structured in a way that allows that to happen realistically. I think that a broadcasting code does that. Like I said, it's something that it's a regulatory code, and it changes you know, from year to year. I think last year or so, or year before last, in Nigeria, there was a new broadcasting code that had all sorts of provisions around promoting local content, things like even banning windowing, where, you know, you maybe give exclusive rights to Netflix, for example, to have your movie on there outside, so there's no other platform where that movie will be on for a specific period of time, just so you get, you know, money for that exclusivity before you then send it across all sorts of platforms. And there was, you know, quite some uproar about that, and whether it was a good thing to ban, you know, windowing, you know, exclusivity windows and all those sort of things. But if you, I don't see where in copyright statute you would have, you know, that conversation, because remember that when you have all these provisions, you know, for promotion and of culture and preservation of culture, you want to give it active force. You don't want it to just lie there as an ideal. You want to hold a particular organization responsible, and who better to hold responsible, for example, in South Africa than ICASA, you know, when they make all this broadcasting code, as opposed to who in the Copyright Act? Would it be the minister? What would the minister, you know, have legislative powers to do?
Cool. Thank you so much for that. With that, and with 3 minutes to spare before the next session, I at least want to give us at least a few minutes to grab a cup of tea. But thank you very much, Chijioke, Vukosi, for joining us today, and thank you very much to the audience, both on Zoom and in person. Tea time.